What if the government accidentally handed its enemies the exact document it spent millions of dollars trying to bury? That's not a thriller plot. That's not a Netflix series. That happened in real life, in America, in 2026. The Department of Justice went to court, fought hard, and won an order that sealed Jack Smith's Mar-a-Lago report forever, buried it, locked it away, made sure no future government, no future administration, no future attorney general could ever use it against Donald Trump again. And then they accidentally sent it to Congress themselves. But here's where the story gets even more extraordinary, because the judge who issued that burial order, the judge whose entire reputation now depends on what she does next, has a record so compromised, so tangled with the very man she's supposed to be judging, that the real question isn't whether justice will be served. The real question is whether she's even capable of serving it. Let's start with what was supposed to stay hidden. Jack Smith was the special counsel investigating Donald Trump's handling of classified documents at Mar-a-Lago. His team produced a detailed report. Volume 1 was released, just like every other special counsel report in American history. But Volume 2, the part about the actual theft of documents and the obstruction of justice that followed, was buried. Judge Aileen Cannon issued an order. That order said, in plain terms, this report, this information, these findings, none of it gets used. Not by this DOJ, not by any future DOJ. Sealed. Finished. Done. It was a remarkable legal move, an entire investigation, years of work, millions of dollars, mountains of evidence essentially thrown in the trash by a single court order. And the DOJ, under Pam Bondi, was perfectly happy to let it stay there, until they accidentally dug it back up themselves. Here's what happened. The House Judiciary Committee, with Jamie Raskin serving as ranking member, had been requesting documents from the Department of Justice, and the DOJ sent them a package. Inside that package was a memo from January 2023 written by Jack Smith's team that outlined something very specific: Trump's profit motive. The memo argued that Donald Trump didn't just carelessly mishandle classified documents, he kept them deliberately, strategically, because he saw financial value in them. War maps, intelligence briefings, documents so classified that only 6 people in the entire United States government were authorized to see them, one of whom was the president himself. And according to the memo, Trump was showing these documents on airplanes, waving them around, storing them in bathrooms, ballrooms, and under pool tables at Mar-a-Lago like they were old magazines. This was the information Judge Cannon had ordered buried, and the DOJ, Pam Bondi's DOJ, Trump's DOJ, sent it directly to Congress. Jamie Raskin said it best: "All I did was release the document they sent us." Think about what that means. The government that fought to bury this information accidentally exhumed it. The DOJ handed the opposition exactly what it had spent years trying to keep hidden. And now everyone knows. The secret is out. And Judge Cannon's order, the one that was supposed to make all of this disappear, has been violated by the very people it was designed to protect.
Which brings us to the person everyone is now watching. Judge Aileen Cannon was appointed by Donald Trump. That alone is worth knowing, but it's what came after the appointment that tells the real story. During Trump's presidential transition, Cannon's name appeared on the shortlist for Attorney General of the United States. It leaked, it was reported, it was never denied by the Trump administration. Most federal judges, faced with that kind of public conflict of interest, would step back, would recuse, would say, even for appearances, "I cannot be the judge on matters involving the man who considered me for his cabinet." Cannon did the opposite. She stayed on every Trump-related case in her jurisdiction and kept ruling. She tried to interfere with the Biden-era investigation into Mar-a-Lago from the very beginning. She attempted to intervene in the search warrant process. The 11th Circuit Court of Appeals reversed her. Twice. She was overruled by a higher court, twice, for overstepping her authority in ways that consistently benefited Donald Trump. The chief judge of the Southern District of Florida, Judge Altanaga, reportedly told her directly, "You don't have enough experience for this case. Step aside. Let a more seasoned judge handle it." She refused. And now there is speculation, serious, credible speculation, about why. Because Cannon's name isn't just being floated for Attorney General anymore, it's being whispered in connection with the United States Supreme Court. And if that's the prize she's playing for, then every ruling she makes, every order she issues, every defendant she protects starts to look less like justice and more like an audition. Here is where Judge Cannon stands today. Her own order has been violated, the information she sealed has been released, and she is the only person in a position to do anything about it, because there is no longer any independent party in the Mar-a-Lago case. It's Trump's DOJ on one side, Trump himself on the other. No independent prosecutor, no neutral party, no one to file a motion. Only Cannon. Federal judges have what's called inherent authority. They don't need anyone to bring a case to them. They can initiate contempt proceedings on their own. They can issue an order to show cause, essentially demanding that the DOJ explain why it violated the court's ruling. That power exists precisely for moments like this one. Jamie Raskin has called for her to use it. Democrats on the House Judiciary Committee have called for her to use it. Legal experts have called for her to use it. And if she doesn't, then the next question becomes one that nobody wants to ask, but everyone is already thinking. Should Judge Aileen Cannon be impeached? Predictably, the White House didn't address the violation. They attacked Raskin. Press Secretary Caroline Leavitt called his letter a cheap political stunt. She called Jack Smith a liar and a fraud. She said the information in the memo was unverified and never made it into the indictment. But here's the problem with that response. Raskin didn't write the memo. He didn't create the document. He didn't manufacture the evidence. He simply released what Pam Bondi's own Department of Justice sent him. If the document is a problem, the DOJ created the problem. If the information is embarrassing, the DOJ made it available. You cannot attack the messenger when your own office delivered the message. Step back and look at the full picture. A judge appointed by Trump, shortlisted for his cabinet, rumored for his Supreme Court, has never ruled against his position, issued an order burying the evidence of his document theft, and now sits silently while that same order is violated by his own DOJ. Imagine a referee in a championship game who was hired by one of the teams, is hoping to be promoted by that same team, and has called every close play in that team's favor for 3 years. And now that team has just broken the rulebook in front of everyone, and the referee is looking the other way. At what point does the referee stop being a referee? That's the question at the center of this story. Not just whether contempt proceedings happen, not just whether Volume 2 of Jack Smith's report ever sees daylight, but whether the American justice system can function when the people enforcing the law and the people breaking it are working toward the same goal. The document they tried to bury is out. The violation is on the record. The whole world is watching, and Judge Cannon has to decide right now in front of everyone whether she is a federal judge or just a player on the team.